Now,
My
before we begin, Mr. Dorset and Ms. Smithen, can I suggest that as there may be a time delay in our hearing you, that it would be helpful if you were to speak slightly more slowly than usual. And if one of us wants to interrupt and ask you a question, we will raise our hand so that you'll be able to see that there's somebody wanting to ask a question right away. And if you could then stop, we can ask the question. Okay? Well, thank you very much.
thank you, Madam.
Yes.
Thanks, my lord.
My Lord, David Dorset, on behalf of the appellant, Ms. Smitten, on behalf of the respondent. My Lord, our case is a case that deals with exceptional circumstances under Part 13.32 of the CPR that allows a default judgment to be set aside. Our case is a relatively simple case in terms of the argument that we will be putting forward. The case put forward by the claimant was that the defendant was the owner of a motor jeep that was involved in an accident in July 2011. That is made clear at page 4 of the record, paragraph 1 of the statement of claim. There was an application to set aside the default judgment that had been entered against the appellant, and of critical importance, and in fact, the only matter that is relevant really is what is seen at page 13 of the record, where the grounds being item 1B. Page 13 of the record, item 1B. The ground of the set-aside application was that the claimant, as a matter of law, was not entitled to judgment, and it is not the law that ipso facto the owner of the vehicle is responsible for injury or damage done by a driver who is alleged to have driven the motor vehicle in a negligent manner. In any event, the defendant, who is the appellant in this matter, was not at the material time the owner of the vehicle alleged to be involved in the accident. Now, my Lord, at the High Court, it was in fact a concession that the defendant had sold the vehicle. This is found at page 52 of the record, where the claimant, under the heading of exceptional circumstances, in the written submissions at paragraph 20 of the written submissions on behalf of the claimant, admitted.
Mr. Dorset, can you give us a page number?
Yes,
Page 52.
Oh, page 52.
Yes.
Thank you.
Yes, page 52. Page 52. And at page 52, the heading of that portion of the submissions is exceptional circumstances. And at paragraph 20 on that page, it is stated that the applicant / defendant, who is the appellant in the appeal, sold the vehicle in question to Luis Hernandez. They continue to say that while he parted with possession, he retained ownership of the same. And then they continue in that particular paragraph, saying, in essence, that because he got the purchase price, he was under a duty to see that the insurance was in place. My lord, when the matter came to the Court of Appeal, Mr. Meyer, the appellant, filed an affidavit opposing the application for leave to appeal in the Court of Appeal. The affidavit of Mr. Meyer is to be found at page 84 and 85 of the record. It begins at page 84, and more substantively, the facts that are rehearsed at page 85, paragraph 5, where he states, the simple fact is that I sold the Montero in April 2011 after I sold it to Mr. Hernandez involved in an accident. I cannot see how I can be involved in this legal matter. The new owner of the vehicle is the one that really should be involved in this matter. My defense is that I was not the owner of the vehicle. Mr. Hernandez was the owner. If there is any doubt as to Mr. Hernandez's ownership of the Montero, he can provide a witness statement at trial, or witness summons can be issued to compel his attendance. Attached to his affidavit are certain documents, beginning at page 87 of the record. And at page 87 of the record is an agreement dated the 15th of March, 2012, where Mr. Hernandez and Mr. Meyer have signed off, speaking to the facts that the vehicle was in fact sold. There is also at page 88 an invoice of sale from April 2011, which indicates that the Montero, the Mitsubishi Montero, was sold for a price of $34,900. Then at the next page, page 89, there is a bank statement, and in the credits column, the third entry in the credit column shows the payment of the purchase price of $34,904 into the banking account. Now, it appears that this affidavit did not make it to the Court of Appeal. Affidavit filed on July 17, 2015, as seen in the court stamp at page 84 of the document was filed in the Court of Appeal Sub-Registry in Antigua, but evidently did not make it to the Court of Appeal Registry in St. Lucia. And the reason we say so is because when the matter came before the Court of Appeal in St. Lucia, there is in the recital the various documents that were being considered by the court at the application for leave to appeal, and conspicuous by its absence is the fact that there is absolutely no reference to the affidavit of Mr. Meyer that had been filed on July 17, 2000, and be that as it may,
Mr.
the
Dorset,
Court of Appeal.
Mr. Dorset, did you not appear for Mr. Meyer at that hearing?
No, my lord. The system is that these are done on paper before a single judge. There is no appearance.
Oh, I see.
By the parties. In fact, this entire appeal, it was done on papers only, with no appearance by any of the parties. That is how this particular appeal was handled. It was not by choice of the parties. That is how the court chose to handle the appeal.
Can I ask you about the invoice which is at page 88 of the bundle and compare it to paragraph 33 of the Court of Appeal at page 68.
Page 68?
This is the master's.
The master.
The judgment at page 68 is the judgment of the master, not the Court of Appeal.
Oh, is it the master? Right. Okay.
Yes.
But the reason I'm
Court of
asking...
Appeal judgment begins.
The reason I'm asking is because of the date on the document, and it doesn't really matter where it comes from. It's the 11th of April, 11 on 88, and it's given as the 11th of April,
Yes,
2014 in paragraph 33. Is that the same document?
Let me just refresh myself. Yes, apparently that is a typographical error.
Fine, thank you.
On the part of the master.
Right,
Yes.
thanks.
Yes, but be that as it may, the Court of Appeal set aside the entry of the default judgment and reinstated, be that as it may, the Court of Appeal reinstated the default judgment that had been entered against Mr. Meyer. And what we say is that exceptional circumstances exist, even by the Court of Appeal's own summation of what constitutes exceptional circumstances in the record at pages 120 and 121, paragraph 26, which begins at page 120 and concludes at page 121. About midway in the paragraph that is on page 121, the Court of Appeal makes the point that whereas what constitutes exceptional circumstances will of course vary from case to case, she gives an example of a defense that is being put forward that is a knockout point. And what we respectfully submit, that the circumstances where a person in a case like this is not in fact the owner of the vehicle, that circumstance constitutes a knockout point. As can be seen from what I would consider the head note from the Court of Appeal judgment at pages 106 and 107 of the record. At point 6, at the bottom of page 106, speaking of what constitutes exceptional circumstances, the Court of Appeal, at least from the head notes, is suggesting that it followed the learning in the what I would call the Wire case, the case of Elvis Wire versus Alvin Edwards. That case, my lord, begins at page 310 of the bundle, and at page 310, continuing in the judgment towards page 321. Reference is made at paragraph 32 of the new approach that is being undertaken and is illustrated by the case of Thomas and Christian. Given the rigidity of the previous rules and the change that came about with 13.32, and the point that was made there, as seen at page 322 of the record, is that the change came about to dilute the rigidity of Rule 13.31. Now, the Thomas v. Wilson case is in fact included in the record beginning at page 402. And the portion that is mentioned there in the Wire case is at page 403, the second paragraph of the judgment, where it makes the point that the new rule is to give greater latitude to set aside a judgment to do justice between the parties. And the last line, the flexibility of the English court in setting aside the default judgment was clearly articulated in the case of Evans v. Bartler. The primary consideration being whether there are merits to which the court should take heed. And in fact, we have reproduced that case, and it is, that particular extract is at page 400 of the record. Page 400 of the record, beginning at line 4. And what is clear is that the change in the rule brought about by 13.32 is to bring us back to the position where the overriding principle, if I may say so, is that as expressed by Lord Wright. In a case like the present, there is a judgment which, though by default, is a regular judgment, and the applicant must show grounds why the discretion to set aside should be exercised in his favor. The primary consideration is whether he has merits to which the court should pay heed. If merits are shown, the court will not, prima facie, desire to let a judgment pass on which there has been no proper adjudication. And with respect, this is what we say we have right here. The Wire case, which the Court of Appeal relied on, makes clear that if there is a circumstance, that goes to the basis of the claim, such a circumstance can constitute an exceptional circumstance meriting the court, in the exercise of discretion, setting aside the judgment. And that is made clear in the Wire case, beginning at pages 324 and onward in that particular judgment. And one of the exceptional circumstances arising in that case, which moved the Court of Appeal in that case to set aside the judgment, the default judgment, was that judgment gave relief that was not available as a matter of law. And what we say, as a matter of law, the non-owner cannot be held liable for an accident when he has sold the vehicle. And that is very clear at paragraph 43 of the judgment in the Wire case. Page 325 of the record, page 325, paragraph 43. The issue of what amounts to exceptional circumstances within the meaning of sub-rule 13.3, so 13.2, I believe it should read 13.32, will vary from case to case depending on the facts of each case. In this case, we find that the two circumstances above, one of them being relief not available as a matter of law, that the appellants rely on are exceptional in that they go to the bases of the claim and, if correct, will result in the dismissal of most of the claim. And that is what we say is present in the instant case. Mr. Meyer says, and that is supported by documents, that he was not the owner. He sold the vehicle several months prior to the accident. That circumstance, we submit, is an exceptional circumstance warranting the setting aside of the judgment. I don't think I can speak more on that particular point. That is the central plank of our appeal.
Could I,
on the subsidiary point, yes.
excuse me, Dr. Dawson, could I just clarify the Thomas case, which you referred us to, Thomas and Wilson Christian, the exceptional circumstances,
Yes.
I think, were identified at page 405 in paragraph 5, where he talks about the combination of impecuniosity, ignorance, indisposition, and so on.
Yes.
Those were the exceptional circumstances there. I'm not quite clear what the exceptional circumstances were in the Wire case at page 325.
Yes.
Was it, can you help
Yes,
on
in
that?
the Wire case, yes, certainly, my lord. If you go to the Wire case, which begins at page 310,
Yes.
it begins at 310 in the part of the judgment beginning at page 323. Judgment applying to a non-party. That is a non-party that did not apply for default judgment. There were a number of parties, there were a number of claimants. There were in fact two claimants in the Wire case. One claimant applied for default judgment, but default judgment was entered on behalf of both claimants. That was the exceptional case or circumstance in the Wire case, one of the exceptional circumstances. The other, as noted at page 324 of the judgment, the heading, judgment gave relief not available as a matter of law or on the pleadings. And in that case, in the Wire case, as a matter of law, certain shareholders were seeking remedies that were only available to the company. And what we say as a matter of law in our case, judgment cannot be entered against a non-owner of the vehicle. It could be entered against the owner or to the person who is operating the vehicle under the owner's direction. That is totally absent in this case. The vehicle was sold several months before the accident, and Mr. Meyer, the appellant, had absolutely no more dealings. And in fact, he had given direction for the transport board to initiate the process of going through the formality of the change of ownership process. So he had sold the vehicle and had done all that was required of him to complete the sale. And that is what we say, we have a situation here where judgment as a matter of law
I think
cannot be entered or ought not to be entered against Mr. Meyer.
Dr. Dorset, in answer to the question that Lord Carnwath asked a minute or two ago about the reasons put forward for the delay in the Wire case, I think one finds at page 319 in paragraph 28, the reason advanced was to do with difficulty in obtaining or finding the documents that were necessary in order to prepare the defense to the case. And
Yes.
Yes, that appears to have been the excuse put forward for the delay there.
But that wasn't the exceptional circumstances, because they didn't get
No,
home
that was not
under
the exceptional circumstance.
Rule 3.1. They got home under exceptional circumstances.
Yes.
And that seems to have been, as you say, the point at paragraph 38, that it was a sort of, the claim must fail because it was against the wrong people.
Yeah.
Is that the point? It was against the
Yes.
shareholders, when the shareholders
That is the point.
aren't the company. But in this case, your problem is surely that the master found that you hadn't satisfied him that you weren't the owner when you put these documents before him, but he was not satisfied. So that was an issue.
Yes, but as I said, the concession, as we have pointed to at page 52, is that it is common ground between the parties that the vehicle was sold. So that really is not a debatable point.
Yeah,
Right at page 52, that is the submission that was made.
But if you read what is said there, although it's accepted that there was a sale, what's said also goes on to make it clear that they contend that ownership remained with Mr. Meyer. It's certainly
Yes,
not
I know, but what we say, that kind of argument we respectfully submit ought not to be accepted. If you sell something, you're no longer the owner. That is what we say. Something has been sold, you're no longer the owner.
May I ask a question?
Yes, of course.
May I ask you this, please? You referred us to the evidence that was, as I understand your submission, submitted to the Court of Appeal, but you say for some reason the Court of Appeal did not consider it. My question is this. Am I right in understanding that all of the materials that you have taken us to were in fact before the master in any event?
Yes, my lord, with one exception. If you look at the application to set aside the default judgment,
Yes.
which, well, more so the affidavit, which begins at page 16 of the record. Page 16:16, and the exhibits in support of the application, numerous exhibits, but in particular, it explains who Sugar Mill was. You see at page 31 of the record, the bank statement showing the purchase price that was paid.
Yes.
We also see the letter at page 32
Well, I beg your pardon.
saying
Sorry, just
to the transfer award.
I beg your pardon. Just before you go on, the account at page 31 was before the master, I think, was it
Yes.
not?
And
Yes, this is before the master.
And Dr. Dorset, was the affidavit at NS 16 not also before him? It's dated the 3rd of October 2014, and the master
Yes, that,
dealt with the case after that date. His
Yes.
judgment
So
bears
this
dates in December 2014 and February and June of 2015. It's on MS 53.
yes, my lord. So, yes, this affidavit would have been before the master.
Yeah.
And attached to the affidavit are the documents that I have explained, particularly page 31, showing payment made into the account, page 32, where Mr. Meyer is writing a note to the transport board. The note says, please accept this notice as authorization from the sugar mill to allow J. Meyer, which is a son, to sign documentation for change of ownership from Montero to Luis Hernandez. And the date is 8 April 2011. The date of that document to the transport board is 8 April 2011. Yes.
Going back to paragraph 33 of the master, I think all the dates are wrong in that paragraph because they're 2014. And in fact, they're all referring to these documents, aren't they?
Yes, I think regrettably there is that type of graphical error.
And also in 34, the date is wrong there for the bank statement.
That is, yes, that is correct.
That's 2011 as well. So these documents were not only before the master, but actually noted by him in his judgment.
Yes,
Yes.
yes. So the document at page 31, page 32, page 30, and page 33. The only additional document that would have been before the Court of Appeal is the document that is seen at page 87. That particular document was not before the master. Page 87 of the record. The document dated 15th March 2012. So I hope I've answered the question on that particular point.
Can I just ask you about the document that your side put in front of the Court of Appeal, please? I think, I just want to be sure I've got the right one, that it's dealing with the question of ownership at page 95 of the record. At paragraph 7.
At page 95 of the record is...
That's your document, isn't it?
It is my submission. It is my submission that was made to the Court of Appeal.
To the Court of Appeal. And
yes, and where basically...
I was just going to ask you, is that the only submission that you made to the Court of Appeal?
No. This submission was only related to the point of leave. This was not the submission in the substantive.
Well, I thought that leave was granted on the 22nd of July, and this is dated the 24th of August.
I apologize. I apologize. I am in error on that point. I apologize. Yes, this is in fact the submission of the respondent.
Right. So the passage
after
paragraph 7 deals with the question of ownership.
Yes.
and it doesn't go into any of the evidence of ownership. It simply makes a bald statement that it had been sold. Is this the limit of what was put before the Court of Appeal on the argument about the ownership?
Yes, my lady. Yes, but quite frankly, there was somewhat of an expectation that the Court of Appeal, when it comes to Antigua, would have heard the appeal and decided the matter, but it chose instead to consider the appeal on paper without notice to the parties. That is the way it was proceeding. And it's because of the fact that there was no oral hearing. Counsel didn't have the opportunity to ensure that the Court of Appeal had before it all the relevant documents for consideration and to expand on the skeletal arguments that were before it. And so it was, quite frankly, a combination of what we consider unfortunate circumstances. The Court of Appeal apparently not having the document and the matter not being heard orally, as is sometimes the case in these kind of appeals, interlocutory appeals.
I have another question. Mr. Dorset, you said to us, I think, at the outset of your submissions that there was a schedule of the documents to which the Court of Appeal actually referred. Is that correct?
Yes, my lord. Page 92 of the record. Page 92 of the record, and it says, before her ladyship, page 92 of the record. Before her ladyship, the Honorable Madam Gertel Tom, Justice of Appeal, on the 22nd day of July, 2015, and then it catalogues what was before the learned judge.
This is,
upon reading the notice of application.
This is not at the stage of the appeal itself, but at the stage of granting leave to appeal, I think.
Yes, that is correct. And there is no reference in the judgment, certainly, to any of the documents that had been filed with the affidavit of Mr. Meyer.
But Mr.
So
Dorset,
apparently it's error.
Mr. Dorset, isn't it inevitable that the Court of Appeal would have had in mind the relevant documents if they read the Master's judgment?
Well, the best I can say, I think we would hope so. We would certainly hope so. But that is, my lord, is the danger of when there is not an oral hearing. We are not able to confirm and to ask what documents are before the court, or that the court is able to see or have command of. It is unknown. And you can see, my lords, at page 103 of the Court of Appeal judgment, it says there, on written submissions, there's no hearing.
Yes.
Page 103, no hearing.
Yes, I think that was the same. It was the same in the Wire case that you took us to earlier, where you also appeared, I think.
Yes. Yes, my lord. As to the main point of our appeal, I don't think I can usefully add much more. As to the subsidiary point, those subsidiaries still, we think, a point of some importance. There appears to be some common ground, and I hope I'm not misreading the submissions from my learned friend, but there seems to be some common ground that the decision of the Court of Appeal was in fact a final decision, and it being a final decision, we were entitled as of right to be granted leave to appeal to Her Majesty in council. There was and is a genuine dispute between the parties as to whether or not exceptional circumstances exist, and so we were entitled to have been granted leave to appeal by the Court of Appeal. And so, my lords and ladies, unless I can be of further assistance, I would be prepared to rest there.
Thank you very much indeed, Dr. Dorset. It's a very clear submission and we understand it. Thank you. Ms. Smithen.
Much obliged.
Good day, my lord, my ladies. My learned friend, Dr. Dorset, would have started his submissions by stating that the matters in issue in this appeal are simple, and that the appellant's case is a simple one. On behalf of the respondent, we share that same view. The legal issues involved in this appeal are not overly complicated. They're not technical. They're simple. And the respondent's simple response to what we consider the principal issue in this appeal, the knockout point issue, as we have termed it, is that the learned master in his ruling was very clear. He found that the vehicle was owned by the appellant, Ed Meyer. This can be found at paragraphs 32 to 36 of the ruling at page 67 of the record. In particular, I think it is very apt to refer to the master's exact finding at paragraph 36, where he said that the appellant, Ed Meyer, and I'm quoting, could have placed evidence before the court besides the registration certificate to show conclusively that at the date of the incident, ownership of the vehicle resides in the sugar mill shop or had been transferred to Mr. Hernandez. However, there is no evidence before this court that satisfies me that the vehicle was owned by the sugar mill shop or that the registration was transferred to Mr. Hernandez at the time of the accident. That leaves the statement in the police report that the vehicle belonged to the applicant. This is a definitive statement from a state official which has not been refuted by anything placed before the court by the applicant. My lords, my lady, the master in this matter, it is our submission, was the fact-finding tribunal. the appellant made his application to set aside the default judgment. Under the rules CPR 13, the appellant was required at that time to provide all necessary evidence to establish that his defense constituted a knockout point, as coined in the learned authorities referred to by counsel for the appellant. Dr. Dorset would have taken you through the various evidence that was put before the learned master and indeed the Court of Appeal. These can be found at pages 31 to 33 of the record. So it was therefore already before the master that information, the bank statements, the other documents at pages 31 to 33 of the record. And having seen all of that evidence, the master came to the finding that the appellant failed to establish that he was not the owner of the vehicle. As a result of this, my lord, my lady, what the appellant is now asking the court to do, Her Majesty in counsel to do, is to reverse this factual finding of the learned master, which had been accepted and endorsed by the Court of Appeal at paragraph 24 of the judgment of the Court of Appeal, where reference was made to Mr. Meyer himself as the owner of the vehicle. And that can be found at page 103 of the record. It is trite law. It is well established in legal principle that an appellate court should not interfere with a first instance judge's conclusions on primary facts unless the appellate court is satisfied that the court below was plainly wrong. Based on the case of the appellant, therefore. Yes, my lady.
The Court of Appeal did interfere with the finding based on vicarious liability. It may be my fault, but I've not seen in the pleading the allegation which the Court of Appeal says the master omitted to note. Could you direct me to it?
The master omitted to note. No, that is not my submission, my lady. I'm not sure I'm understanding your question.
Yes, well, at paragraph 23 of the judgment of the Court of Appeal, the Court of Appeal says that I alluded to the fact the learned master appears to have not paid regard to the amended claim. Had he done so, he would not have been able to conclude, as he did in 37, there were no averments of any sort on the statement of claim at the material time. Mr. Hernandez was using the vehicle as Mr. Meyer's servant or agent. Had such a statement then been wholly absent from the claim, this criticism would be justified. However, the first paragraph of the amended claim states that it is against the defendant for personal injury, etc., caused by Mr. Hernandez when acting as an agent?
I think page 2.
In the amended statement of claim, the amended claim form, sorry,
But that's not made
which
good
is
by the...
on page 2.
But when we get to the
Yes,
amended... I'm sorry.
Yes, my lady. The reference I had made earlier to the Court of Appeal judgment was paragraph 24, not 23, paragraph, yes, 24 of the Court of Appeal judgment in relation to the Court of Appeals endorsing or accepting of the master's finding that Mr. Meyer was indeed the owner of the vehicle. This is at page 103 of the record. And I will quote for ease: the alleged tortfeasor in relation to the claim for breach of statutory duty is Mr. Meyer himself as the owner of the vehicle, who is alleged to have breached his statutory duty to the third party, Mr. Baynes, in failing to have in place a policy of insurance. It was that reference.
Yes, but although in the
highlighting
claim
for the
form there's an allegation that that Mr. Hernandez was the servant, that is not made good by the amended statement of claim, where the allegation of breach of statutory duty is different.
Yeah.
So that by the time we get to the amended statement of claim, the case has changed.
It's the same date.
That's what the Court of Appeal is dealing with in their paragraph 23, isn't it?
Yes, which is the where I was asking.
That is in.
They're the
Yes,
same
that's
date.
what has been specifically dealt with by the Court of Appeal.
I mean, the amended claim form and the amended claim seem to be the same date. And the Court of
Yes,
Appeal
they
seems
are,
to
my
have taken
lord.
the view
And-
that they should be read together so that there was a sufficient allegation. Do you have any
That
explanation?
is yes.
Do you have any explanation as to why the amended statement of claim didn't repeat the allegation?
My lord, I think the drafters of the document at that time took the view, and it was their interpretation as now endorsed by the Court of Appeal, that the claim form and the statement of claim do not exist in isolation, but are read together. And as such, as the allegation was made that Mr. Hernandez was the servant or agent of Mr. Meyer in the amended claim form, that in itself was sufficient to raise that point and alert both the court and Mr. Meyer as the defendant that was a live issue to be addressed in the claim.
But the fact he was not owner, the fact that he had not shown that he was not owner, would not have a bearing on the question whether or not Mr. Hernandez was a servant. You can still have your servant drive a car even if you don't own it.
If there has to be ownership in order for a servant or agent to have permission to drive the vehicle. Because the point about being a servant or agent, it's a case of consent, it's a case of permission, and only the owner of the vehicle can give that permission for another individual to drive their vehicle as their servant or agent.
Well, if somebody makes a mistake and they think they're owner and they authorise somebody to drive the car, they're not liable. Is that right?
If someone, I'm just trying to understand the question, if someone thinks they're the owner and they mistakenly think that and they allow someone to drive the car, if they're not liable. It would really depend. It would really depend on the circumstances, my lady.
Yes, it seems Section 3 is talking about use and giving permission for use, a factual issue which isn't really dependent on this question of ownership. But be that as it may, I was just putting to you that the questions of whether he was a servant or agent and the questions of ownership are actually independent of each other.
In that scenario which my lady just gave, I certainly take the point that they can be independent of each other. But in the facts at hand, my lady, they are linked because permission would have been given in circumstances where the appellant, we say, was the owner of the vehicle. But I certainly do accept my lady's observation.
Thank you. Thank you.
I was referring to the ruling of the learned master in making a factual conclusion that Mr. Meyer was the owner of the vehicle. He failed to prove that he was not the owner. And in such circumstances, by alleging that the non-ownership is a knockout point, the appellant is effectively now asking Her Majesty in Council to reverse a factual finding of a lower court. My last submission, or my most recent submission rather, was that in so doing, we are aware of the well-established legal principles that an appellate court should not interfere with a first instance judge's conclusion on primary facts unless satisfied that the court below was plainly wrong. In this regard, I refer the court to the case of Beacon Insurance Company against Maharaj Bookstore Limited, which at paragraph 12, which can be found at page 210 of the record.
I think you can take it that the board is familiar with the proposition and the authorities that vouch it.
Indeed, my lord, grateful for the direction. As such, my lord, applying this long-standing principle that the primary conclusions of facts are not to be interfered with, then it is my respectful submission that this appeal is bound to fail. This matter was put before the learned master when the application to set aside the default judgment was made. The learned master made his ruling based on the evidence put forward by the appellant that he is the owner of the vehicle. The Court of Appeal endorsed that finding. The Court of Appeal did not seek to overturn that aspect of the master's ruling. Indeed, my lord, there was no counter appeal or cross appeal by Meyer before the Court of Appeal challenging that fact-finding conclusion of the master. Now, at this stage, we're at the Privy Council, the last bite of the cherry. The appellant is now seeking at this final stage to ask Her Majesty in Council to challenge the factual conclusion of the master. It is my respectful submission that the master's conclusion, primary conclusion of fact, must remain intact. It is also my respectful submission that the appellant had every opportunity when he made his application to set aside the default judgment to put forward all the necessary evidence to establish the knockout point that he was not the owner of the vehicle. He failed to do so, and therefore, based on the long-standing legal principles which I have alluded to earlier, the ruling of the master must stand. The master's finding was not completely incomprehensible or unjustifiable, and as such, the appellant's allegation that he was not the owner of the vehicle has been entirely dismissed and countered, not only by the learned master, but also by the Court of Appeal. We therefore have no knockout points, and as such, that defense put forward by the appellant cannot be sustained in law. As such, there is no compelling reason why the appellant, should be permitted to defend these proceedings. If he's only looking, and that is really what the crux of this matter is, his only argument is that he's not the owner. But that has already been dealt with. So once that argument falls away, there can be no other compelling reason why the defense should stand. Further, and I have said this before, but I do think it is worth reiterating and at the risk of laboring the point, the appellant already had his opportunity to raise the necessary evidence when he made his application to set aside the default judgment, and he failed to do so. In this regard, it is necessary to refer to paragraph 36 of the learned master's ruling, which can be found at page 69 of the record. Where the master found the production of the registration information to show ownership by the sugar mill shop, or a statement from Mr. Hernandez that he was the owner as at the date of the incident, might have gone a long way to assist the applicant's case. That type of evidence had not been put before the master. As it relates to the exceptional circumstances point, it is the case for the appellant that the learned master did indeed find that there were exceptional circumstances. And as such, the default judgment should be set aside. But it is necessary to highlight, my lord, that the basis on which the learned master found that there were exceptional circumstances related to his interpretation of Section 3, subsection 1 of the Motor Vehicles Insurance Third Party Risk Act. And also his interpretation as to whether there was vicarious liability based on what was stated in the amended claim form, but not in the amended statement of claim. The Court of Appeal adequately dealt with these issues in its judgment. The Court of Appeal took the view that these matters of exceptional circumstances were incorrectly interpreted and applied by the learned master. Accordingly, the learned master's conclusion of exceptional circumstances was not premised on any finding of fact of the appellant's non-ownership of the vehicle. The learned master applied entirely different considerations in relation to his interpretation of the law and the application of his judicial discretion. These were matters that does not go to the crux of the appellant's present appeal of ownership of the vehicle. It is it's well settled law, and I'm sure I know my lords, my ladies are very familiar with the legal principles, that an appellate court has the ability to look at the discretion applied by a judge and to set aside a judge's finding where the appellate court feels that that exercise of discretion was wrongly applied. And this is what we have in the case before us. The Court of Appeal, in my respectful submission, rightly held that the learned master made errors in principle. This can be found at paragraphs 16 to 22 of the Court of Appeal judgment, at page 360 and 361 of the record. Apologies, I think I have given you the wrong reference.
Well, I think you've given us the...
Actually,
the reference you've
I've
given us...
you the wrong reference. It's 114 and 115. My apologies. Then also at paragraph 27 of the Court of Appeal judgment, at page 120, 121, where the Court of Appeal stated, I would hold that the learned master erred in principle in holding that the claim for breach of statutory duty was not a claim actionable as a private law claim as intended on a proper construction of the Act. He failed to properly construe the Act. This in turn led him into further error in holding that this amounted to an exceptional circumstance. He erred in holding that the claim for negligence based on vicarious liability had not been pleaded, and that this also amounted to an exceptional circumstance. He therefore erred in the exercise of his discretion and was wrong to set aside the default judgment on these bases. I therefore think that it is pertinent that we make this distinction. The exceptional circumstances point found by the master was not in relation to any fact finding of ownership or non-ownership of the vehicle. The exceptional circumstances was based on the master's interpretation and application of the law. He erred in his discretion, is what the Court of Appeal held, and the Court of Appeal therefore took the view that the default judgment was to stand because the master erroneously applied the legal principles as it relates to breach of statutory duty under the Act and as it related to negligence based on vicarious liability. They're two separate issues and they must not be confused, intertwined, or twisted as the appellant has sought to do in relation to this case.
May I ask a question?
It's therefore my respectful duty. Yes, my lady.
Can I just try to sum up where I think you are, or just test it? The position is that the appellant failed to show he was not the owner.
The appellant failed to show that he was the owner.
That he was not the owner.
Sorry, not the owner. Not the owner. Yes, my lady. Apologies. Not the owner.
And so the question then was whether it could safely be inferred that he had given permission for the use of the vehicle by Mr. Hernandez. And the pleading would suggest not that he was a servant, which is the word used in the claim form, but that he must have, that as he was the owner, or had not shown he was not the owner, that Mr. Hernandez must have been driving with his permission. That's an inference that might have been drawn if there'd been no other evidence. But when we're looking at exceptional circumstances for the purposes of your procedural rule, I take it that you would accept that we have to look at all of the totality of the fact laid before the court. It's not just a matter of testing it on the pleading. If the defendant adduces facts so that the court would make an assessment of the facts, it is therefore possible, I just want to test this, can I ask, is it possible that the appellant could, with appropriate evidence, have put before the court sufficient to rebut the inference that he must have given permission for Mr. Hernandez because he hadn't shown he wasn't the owner? There's a linkage between the vicarious liability point and the non-proof of ownership, non-proof of lack of ownership. So can I just ask, when the court is assessing this, and I'm thinking now of the trial judge, I've got all your points about not disturbing the trial judge's finding. He's entitled to look at any facts the defendant puts in front of him to show, on the basis of which the court would then decide whether it was satisfied about exceptional circumstances, not just the pleadings. I think you're nodding, which I think I
yes, my lady. I think there is a delay, my lady. Yes, to a certain extent, of course, any fact that is put before the lower court, he is entitled, the learned master is entitled to consider those facts and make an overall determination.
I'm just trying to...
As it relates to the...
Forgive me, I didn't mean to interrupt.
Yes, my lady.
So what the crucial point at this stage of my questioning is whether or not there was sufficient to rebut that inference. He must have given permission because he was the owner. What he says is, well, I thought I'd parted with ownership. I'd come to an arrangement some months previously with Mr. Hernandez, and I'd been paid the price, so I thought I'd parted with possession and ownership. He had parted with possession. I think that seems to be clear. So the question the court would then have to ask was whether that is sufficient to rebut the implication that there must be an inference of agency. It's not servant agency.
Yes, my lady. The claim was pleaded in the alternative. So on the one hand, there is the breach of statutory duty point, and on the other hand, there is the vicarious liability point. And I agree, my lady, that the master could have made the necessary inferences had the appellant put forward evidence to rebut that he did not give that permission. And even if that point would have failed, my lady, the other aspect of the claim would still stand. That is the breach of statutory duty claim. And on that point, my lady, there has been a failure. So it still comes back to the other point. There's still been a failure to establish that he was not the owner of the vehicle.
But I think that then the difference between us is when does liability get fixed on a person who owns a vehicle. And as I understood it, it was not by virtue of ownership, maybe I'm wrong, but by virtue of use or giving permission for use. That's Section 3.
That's Section 3, my lady.
Yes.
Section 3, let's turn to it. Section 3 refers to, if you permit me to get the reference. I am working with an electronic version, so I'm a little slower. You can crave the court's indulgence. What page is that?
Page 185.
Page 185 of the record. Yeah, so it shall not be lawful for any person to use or cause or permit any other person to use a motor vehicle on a public road unless there is enforced in relation to the user of the motor vehicle by that person or that other person as the case may be. The case law, my lady, in relation to Section 3 speaks very much to ownership, my lady. And that is something that was put before the Court of Appeal at length in the case of Monk against Warby.
At the end of the day, I'm wondering how much this matters. The Court of Appeal proceeded on the basis that there were alternative claims, two alternative bases of claim here. One was a breach of statutory duty, and the other, expressly an alternative on page 2, was vicarious liability for the negligence of a servant acting in the course of his service. And the Court of Appeal point out in paragraph 27 that either basis of claim was capable of grounding a judgment. If that's right, then even if there were a cast iron defence demonstrated to the breach of statutory duty allegation, that would still leave the claim based on vicarious liability, which was defended. The defence denied that Mr. Hernandez was a servant or agent of the defendant and was driving at the material time for the defendant's purposes or under delegation of a task or duty. But clearly there wasn't any knockout point so far as the vicarious liability allegation was concerned.
Yes, my lord. That is an ideal summation of the position. As I had indicated, there were two claims in the alternate, and so even if the vicarious liability point could have been defended as it related to the breach of statutory duty, there was no knockout point certainly in relation to that.
Well, how do you define the knockout point? Because there was clearly fact before the master which showed that there was a dispute as to whether, or, well, put it this way, Mr. Meyer was saying, I did not know I was still the owner, and I thought I had sold it. And it would appear Mr. Hernandez was saying much the same, that he thought he'd got it, that he didn't think that he thought he'd purchased it. Anyway, it maybe we can't take it any further, but it would just be helpful for my note to have a definition of knockout point, because I think you have said that the test in the rules is exceptional circumstances to be determined on the facts as placed before the tribunal making the findings of fact.
Yes. The Court of Appeal touched on the knockout point in paragraph 26, and exceptional circumstances can cover various things. In paragraph 26, the Court of Appeal sort of dealt with it. The learned Chief Justice says, showing, this is page 120 of the record at the last line, starting from the last line. Showing exceptional circumstances under CPR 13.32 does not equate to showing realistic prospects of success under CPR 13.31C. They're not to be regarded as interchangeable or synonymous. And then she goes on to say, is exceptional circumstances is intended to be reserved for cases where the circumstances may be said to be truly exceptional. A few examples come to mind. For instance, where it can be shown that the claim is not maintainable as a matter of law, or one which is bound to fail, or one with a high degree of certainty that the claim would fail, or the defense being put forward is a knockout point in relation to the claim. I'm not sure if that's just a phrase coined by the learned Chief Justice, but that is the explanation that she sought to give as to exceptional circumstances, which from my interpretation means it's an ultimate blow. It makes the claim entirely unmeritable. It puts the claimant in a position where the defense completely wipes out all merit, all leverage, all strength of the claim. That is my interpretation of knockout point. It is not a phrase that I've seen referred to in other cases, but in the context in which the Court of Appeal gave that reference point in paragraph 26, that is certainly the interpretation that I wish to put before the court.
Thank you.
I think that was those are my submissions in relation to the principal issue, the knockout point issue, where it is the respondent's submission that the appellant's defense is not a complete answer to the claim and is therefore not capable of providing a knockout point for the default judgment to be set aside. As it relates to the secondary issue and whether the Court of Appeals decision is the final decision, as my learned friend would have indicated, there is congruity as it relates to the final decision point. The respondent accepts that the Court of Appeal decision was a final decision as it disposed of the rights of the party, and it came to a conclusive determination as to whether the appellant was entitled to satisfy the default judgment or not. However, what the respondent submits is that it doesn't end there, and that the Court of Appeal has a residual discretion, as it were, to refuse leave to appeal on the ground that, in its view, the appellant's case does not raise a genuinely disputable issue of fact or law, or even the Court of Appeal is required to satisfy itself that the appeal to Her Majesty in Council is not an abuse of process. And in this regard, I refer the court to the case of A versus R, a Guernsey case, found at page 370 of the bundle, of the record. Specifically, paragraph 8. Where Her Majesty in Council held that an appellant's appeal as of right does not mean that the Court of Appeal has no control over the appeal. More generally, a Court of Appeal has power to make sure that there is a genuinely disputable issue within the category of cases which are given an appeal as of right. I also wish to refer the court to paragraph 36 of that same judgment, found at page 378 of the record. And this is where the Privy Council said that a similar approach is to be adopted, where a Court of Appeal has that residual discretion to check if the appeal to Her Majesty in Council would be an abuse of process. As such, as of right applications are to be kept within bounds, whilst it doesn't involve adjudication on the merits, it certainly involves some deliberation by the Court of Appeal. And the appeal as of right in section 122 subsection 1A of the Constitution is therefore not merely mechanical. The Court of Appeal has some form of residual discretion. And unless I can be of further assistance, those are my submissions.
Thank you very much, Ms. Smithen. Dr. Dorset.
Yes. My Lord, the case that is before you, it is not concurrent findings of fact. The finding of fact before the master was that there were exceptional circumstances, and that exceptional circumstances warranted the setting aside of the default judgment. That was the finding of fact. the finding of fact in the Court of Appeal was the reverse, that there was no exceptional circumstances. So it's not a situation where one court is rubber stamping the other. One court is in fact overturning the other. The Court of Appeal overturned the first instance. And with respect to what was found by the master on the point of ownership, we respectfully submit that a application for to set aside a default judgment is not a trial, nor is it to be treated as a mini trial, as there is no cross-examination as to the affidavit evidence before the court. The affidavit evidence of Mr. Meyer was that he was not the owner. It wasn't just a bold assertion. He supported it with certain documents, and in particular, that document to the Transport Board, a state authority. And it's not in the bundle, but I am familiar with the case, and your lordships might be familiar with the case. The Privy Council case of Siaga versus Western Broadcasting, a case out of Jamaica, which made clear where there is conflict on affidavit evidence, the court is not in a position to determine exactly who may be right. That would be the proper subject of cross-examination. So it is not proper to say that there could be a proper finding that Mr. Meyer was not the owner. But more importantly, there was a submission on the part of the respondent in this appeal that the vehicle has been sold. And what we respectfully say, once there is common ground on that point, the legal consequences follow. With respect to the point of use, in our written case, we address that point at page 166 of the record, page 166 and page 167. In particular, we have referred the court, or we would refer your lordships to paragraphs 12 at the bottom of page 166 onto page 167, ending at paragraph 16. And the point that is made there, the Monk case makes it clear that permission is permission by the owner. Permission by the owner, not just random permission. Permission by the owner. And what we say, if you read in particular paragraph 13, what the defense was, is that he was not the owner of the Jeep, that is the appellant, was not the owner of the Jeep. He had not caused or permitted Hernandez to use it at the time of the accident. Indeed, there was no allegation in the statement of claim that he had. And this defense, if established, is fatal to the respondent's claim that it is a knockout point. And so we respectfully submit that the case for the appellant is made out. The whole point of Rule 13.3(2) is to get us to the position as stated in Evans v. Bartley at page 400, that the court ought not to, it will not desire to let a judgment pass where there has been no proper adjudication. And that is the case of the appellant, if you may please.
Yes.
If please.
Well, thank you very much indeed. Is that all you wish to say to us, Dr. Dorset?
Yes,
Thank
my
you.
lord. As I said, the last point that we back to page 400 of the record, as stated in the Evans v. Bartlam case.
Well, thank you very much. Well, if that completes the submissions for both parties, the board is most grateful to council for their submissions. I think we've succeeded in using the technology successfully. We've been able to understand your submissions. They've been very clear. We will now take time to consider your submissions and decide what advice we shall tender to Her Majesty. Thank you very much. The court will now adjourn.